George Socia would be very mad if I didn't channel him for a moment, because he gets very mad at the term early case assessment. And he really thinks it's a misnomer. And in some respects, I think he's absolutely right, because we've got our federal Rule 11 that says you've got to do a sincere, deep investigation before you file a complaint. And that would obviously be getting in and wrestling with the facts and doing an assessment. Do you have a valid case, yes or no? And that same Rule 11 obligation applies to filing an answer. You just can't deny things. You've got to have a good faith basis for going through and doing it. And so his plea is that we get away from using the term early case assessment and really talk about it as early data assessment, because you must have done the early case assessment even before you get into the game. So, George, I've channeled you.
Brian, should we tweet that?
You can tweet that. George may thank me for doing it.
Excellent. Okay, let's see.
But one thing Bill asked about, can you classify data, kind of ties into this. As a case goes along, human reviewers inputting into the classifier refine the results, and they start helping you notice similarities in the documents that matter to the case as it evolves. And what I was getting at earlier about attorneys being more intelligent about eDiscovery and judges is, I think that's becoming known. I think it's becoming generally accepted that a lot of analytic tools are very helpful, but they require supervision and oversight. So, so the professional oversight of eDiscovery will always be necessary, and the tools can guide you, but there isn't going to be a big easy button you push that says, here are all your privileged and confidential, otherwise relevant documents all sorted for you.
Just like my iPad computer. Way out in the future.
It's going to be a process.
I think so, yes.
So my experience with ECA to date is that it's out of place. The litigation workflow is still non-cooperative. It's still one side against the other side, and the way that ECA works, just like keyword searching, it really requires some level of cooperation. And so there's still a lot of resistance to old school litigators saying, well, we're going to actually cooperate on electronic discovery. So until that happens, we'll never see the full benefit of ECA, defining ECA just in the Rule 26F context. We do see benefit in ECA, as Browning talked about, and as George talks about it, getting earlier and earlier and better visibility into the data set that we have, whether it's behind the firewall at the corporation, or once that data set has been pulled out of the corporation and is now in the litigation context. I think we'll continue to see ECA get better and better, and we'll see better and better results from it.
I'd pick up what Bill said earlier about parallels between paper days and now, and how useful they can actually be when we're looking at this, and repeat something that Craig Ball said in this room this time last year on the ECA panel, which is that when I was young, the client handed you a file, and you read through the file, and you said, oh, there's something missing here. And you very quickly went back to him and were expected to say, I think you're likely to win or lose, or whatever the case may be. But just as importantly, the cost implications of this are this, this, and this. We've lost that completely. And we're left with one area of business activity where the client doesn't seem to expect us to be able to predict what the costs are going to be. And if ECA isn't for that, then what is it for?
That is an excellent point.
Well,
I fully agree. Yeah.
No, I agree, and I think that the client's answers to some of this is that the cost of this has just exploded. And is it worth it to take something, to defend yourself, because I know it's going to cost $5 million when this is a $2 million case. And I think they're looking to the law firms to take a haircut, to say, you got to figure out a better way to do this. And I'm not going to pay you, because I'm not going to pay you $450 for an hour for mid to upper level associates to review these documents. You just have to come up with a better way, because the ends don't justify the means.
Share my risk.
Very good point. And then it's that ethical question, good question there too, though. So, the next one is for Chris. What eDiscovery issues do you struggle with most today? And what is your biggest headache, and how could it be improved?
my role is carrying messages and education rather than actually doing it. So my biggest headache is necessarily pushing messages against white walls quite often. I struggle with the idea that this very intelligent class of people, lawyers, I should begin by saying no one's saying this is easy. It's a temptation on panels to give the impression that you think this is all easy and that people who can't do it are somehow deficient. This is not easy. And one is preaching to the choir to some extent in an audience like this. When you get beyond that, though, I struggle with this notion that this highly educated body of people, the lawyers, who worry themselves sick about malpractice claims on the one hand and about growing their businesses on the other hand, don't know the rules, haven't read or even caught the drift of the cases. Many of them, not all of them, many of them don't have this most basic understanding of what's at stake here, that this is a dangerous area to tread in, and that there might be other people who would do it better than you as a law firm. You might engage somebody else to help you. Because if you don't, others are going to start eating away at that work anyway. The clients are not going to, as Michelle said, the clients are not going to put up with this for much longer. The other providers of services, including those with pure technology solutions, are going to start eating into the law firms' work in this area. And they don't seem to be defending the ground somehow, in a way one might have hoped for. I went to talk, in England we divide lawyers into solicitors and barristers. Solicitors in law firms, barristers doing advocacy and the drafting and the heavy thinking. And I suggested to these barristers, and traditionally barristers have nothing to do with discovery at all, legislation. They apply their great brains to the intellectual aspects of it and leave solicitors with, as they've always thought it, the drudgery of disclosure, as we call it. And I said to them, why? Why leave that with the solicitors? It doesn't require large numbers of people these days. It requires an understanding of what the technology is. And, to bring this back to ECA, somebody to get in there very early and start getting their arms around the problem. And why should that not be a barrister as well as a solicitor? And they were quite attracted by that. And why should they not be? So that's me, if you like, inciting a different area of business to start eating into law firm work. It doesn't apply quite the same here, but this notion that others are going to start eroding lawyers, law firms' practices for the reasons that you give, that the clients won't put up with it anymore, is a hard one to. It's hard to understand why the law firms aren't getting it.
Well, you see a parallel in the U.S. My experience is that, well, as John Rosenthal was talking about the death of the jury trial, but nevertheless, my experience is it's very difficult to get the senior trial lawyer, the one that's actually going to stand up and try the case, to get involved in electronic discovery early on. It's something that sort of gets passed down the line, and I think in large measure that's because the people that are now the lead trial attorneys got to be in that position before electronic discovery came along. And so if you were to try and sit down, for example, and engage them in a meaningful conversation about the forms of production, what metadata fields are you going to have? You're going to have TIFF and a load file. All of a sudden, you watch their eyes glazed over, and you know they're just not geared to have that conversation. And so I think they avoid it. That generation will pass away.
In our commercial court, increasingly the court is requiring the senior barrister, the one who will do the advocacy, to attend case management conferences. And they're being asked questions. In the commercial court they know anyway, but that's filtering down. Barristers being asked questions at case management conferences are turning to the solicitors to say, what's the answer to that? And the solicitor says, I don't know, leaving the judge rather stuck. And rather too often the judge says, oh, well, let's just tick the box for standard disclosure then. So that's where we've got to tackle it, the judge level.
No, I think that's happening. Yes, well done. So, you know, this was a good transition though to Michelle, and you know, I thought it would be kind of interesting for you to talk about your position because I know it's something new that your law firm has added, and then your previous law firm was the same. And so I think that this is how we're working with maybe some of the, those, lead trial attorneys, we don't want to call them dinosaurs.
Antediluvian.
Thank you, he said it, I did not. Yeah, just, because your background's amazing in this.
Yeah, so
Yeah.
so I started at Goodwin Procter about 3 months ago, and before that time, Goodwin Procter had a lot of support people, but they didn't have any attorneys counseling. So this is an investment that they decided to make. So like Chris said, large corporations have multiple amounts of, multiple counsel, and they're going to find that one law firm is handling this better than another. So I think I've talked to a couple people here as well who this is a new position in their firm too, and you wouldn't believe that AmLaw 50, AmLaw 100 firms didn't have eDiscovery counsel. And I work within the company itself, so Goodwin Procter, our own litigation holds, we're responding to subpoenas and making sure that's in place. So the same thing I would counsel my clients for, the law firm is my client as well. And I was greeted with open arms, and there were a lot of clients that were so thrilled that I was there and that I could provide that service, because I think their in-house people are much more sophisticated than they were in years past. So I think people who are serial litigants, they say, I hire Joe from this corporation to come in and collect my data or to process my data. Well, they're hiring these people away from the vendors and they're bringing them in-house. So from back in the day where we were all up in arms because clients wanted to collect their own data, I think we're much more comfortable with that now, because we know that they know how to do it in a defensible manner, because they have invested in these resources, and I think they expect to see the same from their counsel.
Absolutely, thank you for sharing. That was really good. And it's a great career move for those of you who are wanting to maybe go in-house or even outside counsel into a eDiscovery counsel position.
Yeah, and I think that was a panel this morning, and I think that's what's very interesting and exciting right now is I know that we'll be speaking at this semester at several law schools in Boston, that this is a career. I think all of us fell into it from litigation or from technology. So we all fell into it, and we're breaking ground and leading the way. But this is being taught in law schools now, and this is a career. It's not, I don't think that there's that scarlet A attached to all of us anymore.
Well, you're ahead of us then. My wife, who works at one of the Oxford colleges, took a message from me to a law tutor saying that I would go in and talk to them if they wanted about electronic discovery, and got back a rather snotty answer that was something like, we don't do that sort of thing here. So this opportunity to catch the younger generation as they come in and then have them to influence their firm when they reach them is not being taken up.
Well, I'm interested in Boston. Tom O'Connor is going to be here in a little bit, and I, a couple of years ago, went around to a bunch of law schools and said, we'll come in, we'll teach, we think it's something, and boy, maybe it was our good looks that caused us to be thrown out, but it was, we don't do that kind of thing here. We don't teach plumbing.
Not too bad.
Well, like I think William was saying at the beginning, is we all, this is going to go away. This is a problem that's temporary. It's going to go away. Push it under the rug. Don't pay attention to it, and we'll be good, and we'll continue on with litigation as we know it. But I think it's great that young people are getting involved, because technology is constantly changing, and I think that unless you want to stay ahead of things, I think you become very complacent and very stuck in what you know. So a move a few years ago to producing documents in native, that was unheard of. We just got a handle on TIFF. Okay, we understand TIFF, we understand that works. All right, well, we have to give you some metadata, but not all metadata. And there's a shift, and I think that maybe before it was trying to tell the senior counsel and the trial counsel that, okay, you're not going to print everything out, because this database will be 8,000 banker boxes that you're not going to be able to put in your trunk and bring home. Let's step on the technology bandwagon.